The struggle of Kashmiris are continuing under the occupation, which is fierce, which is deadly, and which is definitely without mercy. So having said that, I would like to notify our participants in the webinar that we will be reserving a few minutes for question and answers after all our speakers are given their chance to provide their expertise. And as the session progresses, if any of our participants would like to ask questions or would request them to write, and we would actually request them to write down in the comments here in the Zoom meeting or on the Facebook live stream. The most relevant questions will be asked. Please write the names of the speaker followed by your question, and we'll ask them on your behalf. And again, we have a set time for this webinar, and since we respect everyone's schedules, so yeah, I think, Afzal, would you like to please continue? Thank you.
Yeah. Thank you so much, Taiba, for the brief introduction. Now, without taking any more time, I would like to open the floor to our first guest speaker, Dr. Patricia Hobbs. The stage is yours, Dr. Hobbs.
Thank you very much for your introduction and for inviting me to take part in this webinar. Certainly, thank you, Taiba, for the thorough explanation and discussion about what's happening in Kashmir at the moment. And certainly, given the several crimes that have been perpetrated there, one would think that India would be potentially liable for not just for human rights violation, but also potentially for an international crime. Now, so what I'm going to do, I'm sort of going through each of the crime, starting with genocide, probably the least possibly contentious, but the least likely to actually find any potential for liability, either in the context of state responsibility, but also in the context of individual criminal responsibility. And also to preempt the discussion is, of course, the fact that India is not party to the Rome Statute, therefore it does not recognize, and it is not within the jurisdiction of the International Criminal Court. Of course, there's always a potential for the Security Council to send that situation to the International Criminal Court, but that's very unlikely as well, given the potential vetoes by certain countries. So, so just to go through the actual crimes. Now, I thought I would start with genocide, and the reason I started with genocide was because it's certainly interesting from the point of view of the definition of genocide, but also from what is happening in Kashmir itself. Now, when it comes to clearly Kashmir and the population of Kashmir, the Kashmiris are part recognized as indigenous people, and therefore within the protection of the United Nations of Indigenous People. And according to this particular treaty, of course, the idea is that before anything is done within the territory of these people, there should be a free, prior and informed consent to ensure that Kashmiris are actually exercising their sovereign indigenous rights as indigenous people. And of course, according to this principle, all peoples have the right to self-determination. And obviously linked to this right is the right to pursue economic, social and cultural development. Now, I've tied up genocide with this particular principle that applies specifically to indigenous people, because the Genocide Convention, or rather the legal definition of genocide, is actually quite narrow. Partly because it does not, the actual definition itself does not include cultural within its definition, although it does include ethnical, but ethnical, as we know, is not in itself very clear in the way that it is applied. Now, also, if you go through the Article 6 of the Genocide of the Rome Statute, which reproduces verbatim the Article 2 of the Genocide Convention, there's certainly some of the elements there that could potentially be applied in the situation of Kashmir, given the summary that we just said about detention, a forcible transfer of people. Forcible transfer is also a transfer of people from India, from the outside territory of India, so Indian territory into the Kashmir territory. The problem, of course, is the definition is very narrow, and it does not allow for potentially of what is happening in Kashmir itself. Now, if you look at sort of causing serious bodily or mental harm to members of the group, for example, given the situation in Kashmir, the potential imprisonment, arbitrary imprisonment of individuals, as well as inhumane and degrading treatment, as well as torture, potentially it could fit within one of those acts of the genocide, either the Genocide Convention of the Rome or the Rome Statute. But as you know, in practice, genocide is very, very hard to prove. And one of the problems with genocide is, of course, the intent, the mens rea for the offense. So unless you have that special intent to commit that particular crime, which is of course, the intent to destroy in whole or in part a national, ethnic, racial or religious group, then it's quite difficult to actually find liability under Genocide Convention. Now, of course, there have been, sort of in recent years, actually after sort of the 1990s, there have been findings of genocide, both in the context of Rwanda and in the context of the former Yugoslavia. But even in the context of the former Yugoslavia, for example, it was only in the context of Srebrenica that a finding of genocide was actually upheld by the International Court of Justice. So this was about state responsibility as opposed to individual responsibility. But of course, we know that other cases did go ahead with regard to genocide from the point of view of individual criminal responsibility. So we also know that in the context of Bosnians versus Serbia, and also Croatia versus Serbia, although some of the acts committed did amount to the actus reus of genocide itself, but there was not enough evidence to actually find that there was a special intent to destroy in whole or in part a certain group of people. So quite difficult, I think, to actually prove at the end of the day. The ICTY, again, in the context of the former Yugoslavia, did find a number of cases related, did uphold in the context of genocide, aiding and abetting genocide. So I think in the context of Kashmir, genocide would probably be the least likely to prove successfully, I think. As I said, partly because of the special intent and the way the legal definition is constructed. Now, when I was, interesting enough, when I was reading about this, the situation in Kashmir is not very different to what's going on in Israel and Palestine, and the way Israel has partly, quite clearly occupied Palestinian territory, and also perpetrated a number of human rights violations in that territory. Now, there are of course suggestions for some writers that of course this is a very slow move to genocide. Okay, it's not as as quick and as clear as it was happening in Rwanda, as it happened in the context of the former Yugoslavia. It's more insidious than that. And this is quite an interesting discussion, but as I said, it's more of an academic theoretical discussion as opposed to whether in fact there could be liability for genocide for acts perpetrated by India in the Kashmir territory. So that's, there's other discussions that are quite interesting here with regard to genocide, including the original viewpoint or the original vision by Lemkin when he did come up with the genocide, with the label of genocide to these particular crimes. It did not, the final definition did not go far enough and did not cover certain groups of people that were originally intended by Lemkin. So that's really in the context of genocide. Now, crimes against humanity, it's certainly different, because crimes against humanity offer the possibilities of the fact that they can be committed both in times of war and in times of peace. So you don't have the extra burden of having to prove whether there is an armed conflict, and of course, and then going on to the debate as to whether the conflict is international or non-international, which in itself leads to other problems and issues. So crimes against humanity has got that extra advantage. And if you look at the list, obviously I use the Rome Statute. I did say before that India is not party to the Rome Statute, but I use the Rome Statute and the provisions set out in the Rome Statute as sort of indication of the crystallized in international customary law anyway. So whether India ratifies the Rome Statute or not, they would be bound to some extent. We don't have a draft on which the Commission has been working for a number of years. But the point is that actually some of the acts, the actual acts themselves listed under the Rome Statute, behavior and the acts committed by the Indian government against the Kashmir people. So when you're talking about, for example, torture, rape, sexual crimes, murder, enslavement potentially, persecution is certainly one that would attract some element of attention, because persecution is identified as a group or collectivity on political, racial, national, ethnic, cultural, religious, gender, as defined in paragraph 3. So it's actually wider than the definition, for example, on genocide that I mentioned earlier. And persecution is effectively the intentional and severe deprivation of fundamental rights contrary to international law. Now, as I understand it, as the new laws came into place last year on the 5th of August, quite a severe curtail of Kashmir's rights were imposed by the Indian government. And so certainly it could potentially fit into this definition. However, the elements here that need to be satisfied are the contextual elements, that the attacks, first of all, we have this sort of notion of attack itself that may be difficult to actually define in practice, and whether the court's definition of attack would actually match what the Indian forces are doing on the ground in Kashmir. But also this attack needs to be part of a widespread and systematic attack directed against any civilian population. Okay, so the idea that it needs to be widespread and systematic, and when he mentions that the notion of widespread is not limited to the number, but it could be also specific territory itself. So that potentially could satisfy the contextual element. Systematic as well, it's sort of part of sort of a wider government agenda. So in furtherance of some sort of policy to commit such attack. Now I'll go back to, so in some ways, some of the elements here are potentially fulfilled. The attack in itself may be questioned because, again, what India has done, and I'm sure India would defend its the actions in the context of its the principle of state sovereignty. They've taken the action to implement those particular laws. And to effectively annex Kashmir into Indian territory. Can you just remind me how much time we've got? Because I don't want to go over time.
You can take 5 more minutes.
Okay, right. Thank you.
Okay.
Yeah, thank you. So from that point of view, so if you look at sort of some of the cases, there's certainly some cases, again, post with Rwanda and Yugoslavia with the ICTR and ICTY, again, we've had some very vivid examples of crimes against humanity. And I think that the one that I would point out more in terms of, it's not maybe as comparison, because I'm not quite sure about the actual civil unrest. So I'm aware of the actions taken by India against Kashmir. So what happened in Kenya after there was civil unrest after an election. And that in itself was deemed to be a crime against humanity. And effectively, actually, in that particular episode, although it was found to be systematic, I use the word only in comparison to previous finding of crimes against humanity, but about 1,000 people were actually killed in the context of the civil unrest in Kenya. So it is possible, as long as the context does match the criteria, that potentially there might be a finding for crimes against humanity for India with respect to Kashmir. Now, I just want to finish off with war crimes and a crime of aggression. And I don't want to talk too much about war crimes because I'm aware that there's another speaker talking about international armed conflict. And I mentioned before, one of the problems with the finding of war crime is that before that there needs to be an armed conflict. Now, it seems to me that India has got an interesting and maybe a more traditional perspective on state sovereignty. I've noticed that it has entered some declarations, albeit resembling reservations, with regard to the ICCPR and the ICSCR. And it's also not ratified, it's not party to the Geneva Convention Additional Protocols of 1977. So from that point of view, we can quickly establish that India would try very hard to contest that there was an international armed conflict. And so you would be limited, not even to the protection offered by additional protocols, but really just under Common Article 3. Having said that, these are basic human rights provisions. And even if it was in the context of a domestic, non-international armed conflict, it was still, some of the acts perpetrated by India could still amount to violation of Common Article 3 in itself. Lastly, crime of aggression, okay. Crime of aggression is very interesting because now, of course, again, I'll go back to the International Criminal Court, which obviously now can have jurisdiction for this particular crime, which also includes occupation. Now, India, of course, was very clever in the way sort of adjusted the constitution and amended some of its domestic laws. But for all intents and purposes, this is an annexation of Kashmir into into India. So, and with the amount of forces that India actually sent to Kashmir, it can only amount to an occupation, which would be covered by the crime of aggression listed in Article 8 of the Rome Statute. And of course, if it was occupation, it would also have, India would also have to comply with the Geneva Convention 4, with the fourth Geneva Convention, with regard to the protection afforded to people in territories. Having said that, Geneva Convention 4 does apply to, just like all conventions apply to international armed conflict, apart from the minimal amount of human rights protection offered by Article 3 itself. So it's not my roundup and my conclusion is actually that it's not clear cut. It's very insidious. It's very similar, as I said, to what's happening in between Israel and Lebanon, and Palestinian, and also the issue. One of these self-defense against terrorism and etc. So very similar to some of the propositions put forward by the Indian government. So in that context, it's probably quite difficult. Obviously, the route to the ICC, to the International Criminal Court, would actually be quite hard unless you have a referral by the Security Council. So the other avenue would have to be a different court, a domestic court that would decide to exercise jurisdiction under universal jurisdiction, for example. Again, that would be quite difficult, but not impossible. And possibly, as I said before, crimes against humanity may indeed be the best way forward. And that concludes my discussion. Thank you.
Thank you so much, Dr. Hobbs, for that brilliant, I think, articulation and how you distinguish between how genocide, the mens rea for genocide, the specific intent is very hard and it's very narrow in its text. So it's very hard to prove. But as you put it, I think very eloquently, crimes against humanity would fit the bill. Now, thank you so much again. And now we'll move towards our second speaker, Advocate Mr. Abdul Rauf Hatana. Please, the floor is yours, and please share with us your perspective.
I'm audible, participants?
Yes, you're audible. Yeah.
Thank you. Very good afternoon to Afzal and Tiba, and good morning to Patricia. Thank you very much indeed for having me here and providing me an opportunity to share my thoughts and my personal position on the issue. Since you assigned me the more crucial area of this discussion, where this conflict falls within, in the jargon of international humanitarian law, whether it is international armed conflict or not, and it was quite catchy title because most of my followers and my friends, my students, they were curious to listen me, and they were curious about, and few of them also suggested that the question may be rephrased, that according to them it may not be something very clear, categorical, that it is an international armed conflict, but I kept their curiosity, and I hope I'll be able to make them clear that whether this situation ongoing in occupied Kashmir meets the threshold of international armed conflict or not. So we will start with where left Dr. Patricia, and it will help me to point out the significance or the consequences of this the war crimes or alleged genocide and some of the other violations of the systematic and while systematic and gross violations of the international human rights law as well. So once these crimes are asserted or established, as Dr. Patricia tried to mention it, and some of the facts do, in fact, attract some of the facts as mentioned by Tiba in her earlier brief. Some of the facts which are going on in the valley, they in fact attract some of the provisions which are mentioned by Dr. Patricia, and indeed these crimes are being committed. It's not only the position of Pakistan or the people from Kashmir, certainly the independent rapporteurs from the United Nations and other independent agencies, they also substantiate this position. But I will start with how to deal with these crimes, since these crimes are heinous. So if the war crimes are being committed, if the genocide is being committed, if the systematic violation of human rights is going on and it's being prolonged, so how to deal with, and what is the answer to this question in international law, particularly and in international and particularly in international humanitarian law? Yes, generally we can find answers to this question in international law, international human rights law, and international humanitarian law as well. But I'll be focusing on international humanitarian law for the moment. So first of all, it is very important why we call that, and you might have guessed that my position is that I believe that this is an international armed conflict. So why we call it international armed conflict? And what if we do not call this international armed conflict? So the atrocities or the violations of the human rights, as mentioned earlier, which are going on in the valley, what law can provide remedy to the affectees, to the people who are aggrieved? So what is to help out the weaker party in this situation? Certainly, one is state, and they have the power and the force and everything. On the other hand, there are people, those who do not have that much strength, that much power. They do not have any backing of state behind them. So they are at least the weaker parties. So law is there to protect and help the weaker party. And in this regard, we being academics, we believe that it is our academic honesty to point out the most appropriate and accurate law which can deal with the situation. So generally, if these things are going on, so the state of India or any other state which is not the weaker party, so I will try to categorize my arguments from the perspective of weaker party and from the perspective of the state or the perspective of the powerful party. So that's why the language high contracting powers has been used in the Geneva Conventions as well. So if these things are going on, so what the weaker party can do? So the stronger party or the state, the aggressor, will obviously, first of all, tag it as this is a kind of domestic disturbance and internal disturbance, and the domestic law is capable to deal with this situation. Certainly, they would not deny some of the violations of the human rights or some of the other liberties, civil liberties, but they will come up with an answer that there is a constitution and there is a domestic law which can address, which can provide the remedies to the aggrieved party. So this is something which is quite acceptable to India, and there is no harm in, there is no problem with regards to this position as long as India is concerned. But why we will not call it the domestic or the internal disturbance? Because the things which are going on are the threshold of the international armed conflict. It in fact governs the situation from the perspective of weaker party, from the perspective of those who are victims and who are at the receiving end. So the other thing from the next step ahead from the internal disturbance, the India would like to call it an internal armed conflict. So okay, if they say that it is an internal armed conflict, even then obviously India will not accept it either as an internal armed conflict. But even if they accept it, the scope of the law or the scope of the regulations which can address the issue from the perspective of the weaker party is the application of Common Article 3 as mentioned by Dr. Patricia. So Common Article 3 provides certain remedies for the situations which are not falling within the international armed conflict, and they are just categorized as non-international armed conflict. So even then, though, if this is recognized, the weaker party will get some sort of remedies, and the liberation movement, the way they are going on, they will have at least some remedies for them. But if we talk about that it is an international armed conflict, then the whole of international humanitarian law comes to be enforced, and it will certainly take care of the weaker party in this regard as much as possible. So that's why this position is certainly denied from the stronger party, and weaker party will always assert for this. Now, any aggressor, any powerful state which is occupying a particular territory, they will obviously not accept that this is an international armed conflict, because the whole range of the international humanitarian law, including the Geneva Conventions and additional protocols and customary international law, will come up to point out their inhuman acts, their war crimes, their violations committed by them of the human rights. So that's why this is not being accepted. My argument precisely, when I take this position that this is the international armed conflict, I am precisely relying on two arguments. And these two arguments are obviously from the international humanitarian law, from the Geneva Conventions. The very first argument which I would like to quote is the Article 2, which is common to all the 4 Geneva Conventions. So Article 2, which is common to all the Geneva Conventions, I would like to read it from the Geneva Conventions, which I hold here. It says, in addition to the provisions which shall be implemented in peacetime, the present convention shall apply. It is common to all the conventions, so it refers to all the 4 conventions. Shall apply to all cases of declared war or any other armed conflict which may arise between 2 or more of high contracting parties. So this is something which generally the stronger party recites, and they do not go beyond this. But I would like to go beyond this. It continues. It says, even if the state of war is not recognized by one of them, and then the second paragraph, the convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. So here I would drag your attention to the occupation. The word occupation has been used here. So in cases of occupation, where one high contracting party is occupying, is an occupier, then this meets the threshold of international armed conflict, and it covers the application of all the 4 Geneva Conventions, because this is article common to all the 4 Geneva Conventions. So in this regard, everybody would like to ask me on what basis I would say that India is an occupying force. So we can substantiate this proposition. First of all, when the partition took place in 1947, so precisely the principle was that the princely states shall decide on their own whether they want to accede with Pakistan or India. So in this regard, Kashmir was admittedly a princely state, and there is no denial of the fact from either of the parties to the conflict. So the accession or the occupation, these are the positions between the parties. So the 2 opponent arguments. So the Indian position is that the Maharaja submitted or rendered the deed of accession, and by virtue of that, the Kashmir became the integral part of the India, and it is not an occupation. On the other hand, the other position is that the the deed of accession was not being recognized legal in the light of international law. So there are many things which have been mentioned and a lot have been written on this. Many people would like to refer Dr. Ijaz Hussein's book, who is a very competent professor in the Qaid Azam University in Pakistan, and he wrote a book, The Position of Kashmir in International Law, Kashmir Dispute and International Law, and he has taken this position that the deed of accession is not legally valid in the eyes of international law, and alleging that this was given under the coercion and under the duress, and moreover, the Maharaja did not exercise it in accordance with the wishes of the people. So Maharaja, though he was the sovereign at that time, but he did not exercise this in accordance with the wishes of the people. And it is a well-known fact that the majority of the population were Muslims, and they wanted to accede with Pakistan. So on these two grounds, and moreover, there is another point I would like to elaborate further on this little later, but I just point out that when this issue was taken to the United Nations, and when this, because of this conflict, because of the armed conflict which taken place in 1948 between India and Pakistan, once this issue was taken to the United Nations in its one of its earlier resolutions, United Nations Security Council provided for that the issue shall be resolved in accordance with the wishes of the people through the exercise of the plebiscite. So here, if the plebiscite was recommended by the United Nations Security Council, it was accepted by both the parties, India and Pakistan. They both accepted that, yes, we can hold this plebiscite. At that point, India did not assert this position that there was a deed of accession, and according to the agreed upon formula, the princely states were on their own to decide whether they will join India or Pakistan. So this position has not been asserted as far as I know. You can correct me. When this the resolution, I am specifically, I'm talking about the resolution number 47 of April 21, 1948. So this is where the deed of accession becomes controversial, and it is not legally or validly accepted document. So in the absence of deed of accession, there's no other fact to accept that the Indian forces occupied the territory of Kashmir against their wishes. And this mentions, the Article 2 also mentions that whether there is an armed resistance or not, though the armed resistance also had taken place, but even if it had not been there, even then, this would have been the occupation, and it is occupation. And what to say, even now, if you just Google and you just find out how many troops, Indian troops are deployed in Kashmir, you will find more than 900,000 troops are there, and only for 12 million or so, how many the population is, you can just mention if you know it exactly. But these are the facts which are even quite familiar, and everyone knows, and well admitted facts. So this was argument number one. The second argument on the basis of which I believe and I assert that this is the international armed conflict, it covers some of the situations, and it is from the one of the additional protocols. It is the first additional protocol, Article 1, Sub-Article 4, which says, apart from the regular interstate armed conflicts, additional Protocol 1 extends the definition of international armed conflict to include armed conflicts in which people are fighting against colonial domination, alien occupation, or racist regimes in the exercise of their right to self-determination. I repeat, in addition to the I just lost. Apart from the regular interstate armed conflicts, Additional Protocol 1 extends the definition of international armed conflict to include armed conflicts in which peoples are fighting against the colonial domination, alien occupation, or racist regimes in the exercise of their right to self-determination. So the right to self-determination against the colonial occupation, colonial domination, or alien occupation. So initially, you will find a lot of decisions and advisory opinions of the international courts and international forums that initially this right of self-determination had been considered within the framework of colonial dominations only. But here it has been very expressly mentioned the alien occupation and racist regimes, the fight against the struggle against the racist regimes in exercise of their right to self-determination. So if a community is struggling against the occupying force or alien occupants for their right of self-determination, then this also meets the threshold of the international armed conflict. And having met this threshold, the whole of international humanitarian law shall be applicable. So again here, on what basis we can establish that whether the people of Kashmir are fighting for their right of self-determination. So what is the right of self-determination? A lot can be said about it. United Nations Charter itself mentions 2 times the self-determination, right to the self-determination. Once in its objectives that the purpose of United Nations is to develop friendly relations among the nations on the basis of the respect for the right to self-determination, and then there is economic and social cooperation shall also be. It also mentions once again that there shall be the right of on the basis of the respect for the respect to the right of the self-determination. So recognition of the right of self-determination is within the UN Charter. It is one of the aims of the United Nations organization. Secondly, from the international human rights law perspective, this is article common to the covenants, both the covenants, international covenant on civil and political rights and international covenant on economic, social and cultural rights. Moreover, the UN Charter does not provide any criteria for the right of self-determination, or it does not gives any definition. But some points are some points and some criteria has been mentioned in the covenants. If you just go through Article 1, you will see, and if the time permits, I just read it for you. It says, all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. All peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case may a pupil be provided of its own means, may be deprived of its own means of subsistence. So international humanitarian human rights law, it is just for the reference of definition and what. So it mentions that wherever there is economic exploitation, there is a exploitation of civil liberties, there is an exploitation of fundamental rights, then obviously the people of that community, the right of their self-determination is certainly recognized in that sense. So this is just for the criteria. However, it may not be very directly applicable in this regard, but without going into the rhetoric of what is the right of self-determination, I would like to mention the United Nations Security Council in its resolutions had admitted this right of self-determination for the people of Kashmir. So it was, as I mentioned earlier, for the first time, the resolution number 47 of April 21, 1948, wherein expressly the right of self-determination for the people of Kashmir was sanctioned and recognized, and it was reiterated in the subsequent resolutions from the United Nations Security Council. So it has been, as I said, no need to go into the rhetoric, what is self-determination, whether the people of Kashmir are entitled to this right or not. What to say once the United Nations Security Council has categorically mentioned it for the people of Kashmir. So once the right of self-determination is recognized, then keeping in view the provision of additional protocol 1, subarticle 4, it meets the threshold of the international armed conflict. So these were two precise arguments. However, we can elaborate further and we can talk more about it. But on these very basis, I would say that the situation going on falls within the ambit of international armed conflict. Moreover, the weakest party's perspective must be kept in the view. Only then we can come up uh, that where we can fix this issue and how we can proceed. And there are some questions which are obviously the time is short. I'm just going to conclude. But the question may be asked about how these violations, if it is an international armed conflict, how the war crimes shall be addressed, how these atrocities shall be addressed. So what would be the appropriate forum? So if questions are asked, then obviously we can respond. So thank you very much. Once again, these were my submissions. Sal, I'm
Sorry,
not.
I think I was muted.
All right.
Thank you so much, Advocate Abdul Rauf Katana, sir, for your articulation of how Kashmir conflict meets the threshold of international armed conflict under common Article 2 to all Geneva Conventions and the first additional protocol, sub-Article 4. We will be moving on to our final guest speaker, our last honorable guest speaker, Ms. Farzana Yaqub. Floor is yours, ma'am.
Assalamu alaikum. Thank you so much for having these discussions and extremely important. Although we must admit that we are very late in this game, but at least the youngsters of Kashmir have taken this responsibility on themselves of not depending on the others to speak about them, but looking for solutions themselves. So it is always such an encouraging sign to see Nasir and youngsters like you playing the frontline warriors. And the most important part for me is not just the fact that we might be able to find some kind of legal solution or that we might find some other solution, but the fact that it is you who is now providing the vocabulary which was missing to really define and explain the issues of Kashmir, be it war crimes and occupying force. These words were seldom used. But now, because of people like you, this is becoming a common understanding of the issue of Kashmir. Um, different. This for me is a success of ventures like this, and we must have these conversations as regularly as possible because the understanding improves when we have such august speakers as Patricia and Mr. Khatana, who are always trying to explain, not only explain these issues, but also the way forward of how these solutions can be executed. Nasir had asked me to speak about, the situation of LOC, and also whenever United Nations UN MOGIP report is shared, so it not only highlights the issues in Indian occupied Kashmir, but it also has a few reservations about Azad Jammu and Kashmir. So if we're around 80 to 90% of that report is mostly about Indian occupied Kashmir, and around 10 to 15% is about issues within Azad Jammu Kashmir, where it is said that a bit of the expression, freedom of expression, be it political, be it media, that is what is felt, is not 100% free. And so it basically depends who has been asked. What happens is that previously, at least till last year, any foreigner who had to go to Kashmir would require a no objection certificate from the Ministry of Interior. That was considered as a severe issue because Azad Jammu Kashmir is a very peaceful place. But when you require an NOC to go to that place, that means that there is a security threat over there, which then means that it is always the threat level is high. And what we have been always arguing is that no, within Azad Jammu and Kashmir, it is extremely peaceful, and we seldom have issues other than the line of control, where we feel threatened by any kind of forces. And by any kind of forces, I mean even us amongst ourselves, we could get angry and use another way of expressing our anger. So we must address the issues that are highlighted in 2020. The issue of NOC, at least to my understanding, was removed. I think it happened in 2019, yes, because I was arranging for a foreign journalist to visit Kashmir, and just on the last day, we found out that we don't need an NOC. So there's a little bit of confusion. Some get away without NOC, and some still need an NOC. So the processes are in the nascent stages. Some people get away and some don't. Also, one of the issues that creates quite a bit of heartburning is that when our Kashmiris come from Indian occupied Kashmir, the common denominator between us is the state subject certificates that we have on both sides. That is what proves that we are Kashmiris. But for an international identification, people of AJK have Pakistani passport, and people of Indian occupied Kashmir have Indian passport. Those are our travel documents. But for us, for Kashmiris who come through Wagah border or any other border outside of Kashmir, when they have to enter Kashmir, they face problems. And that is something that we need to resolve, not only within the AJK level, but also at the legislative level in Pakistan. LOC is, even at the best of times, a very dangerous place. People are regularly shot at. Cross-firing happens all the time. Civilians on both ends are Muslims, and most of them are families. So half the family is on this side and half the family is on that side. Now for us, what does family mean? It does not mean just the close family, like, children and parents. For us, family means brothers and sisters and nephews and nieces, and extended family is also close family. The bloodline, the tribe is family. So maybe a sister's family is on this side and her brother's family is on that side. What we have seen is that Pakistan it does not respond at the level that Indian fire is received. One of the reasons is that Kashmiris are very apprehensive that if both the countries would start firing at an equal aggressive level, we the civilians would face the brunt, because it is we the civilians who mostly die. Sometimes in very serious occasions, the forces or the army personnel, they die, but mostly it is unarmed civilians who are the casualty or the collateral damage. We're mostly asked that why are people living in these dangerous zones? We need to understand the psyche and culture of Kashmir, and not just Kashmir, but most probably of Asia. One, we always work towards ownership of land. Two, we always work towards ownership of the house that we live in. It is very easy to say that we can shift these people to somewhere else, but AJK is a very small parcel of land, and so it will be very difficult to move people from their lands, their ancestral lands, those lands that they own, to lands that they do not own. And even if the government was to provide them safe spaces and land of ownership, it would never be as big a parcel of land that they originally owned. So this is a very painful shift, and that is why, even though as dangerous as it is, people still prefer to live on their own land, because we literally die for our land. we defend our land. And that is why Kashmiris say that India is occupying and we need to defend our land, because they're actually trying to usurp our land. All the actions post and pre 5th August 2019 is not only about the land but about the human beings themselves. So we are being occupied and literally sacrificed at a physical level, at an emotional level, at the property rights level, at all the levels that one can explain. So that is why these people stay where they do stay in such dangerous lands. And emergency services, be it medical services or evacuating them, especially when a crossfire is going on, becomes extremely not only dangerous, but sometimes rather impossible, because while the crossfire is going on, you cannot have any kind of vehicles traveling to these places. Uh, we do not see India respecting the white flag or any kind of a symbol that represents international peace organizations. And other than the UN MOGIP, it is really difficult for international observers to go there. ISPR arranged a trip for international uh, the ambassadors and some other foreigners to visit the LOC, but then that requires a heavy deputation of security personnel, and that is not possible all the time. And um, we can't make these separate, constant, heavily securitized arrangements pending on how the Indian army might at any point of time start firing. So that is a serious issue that we need to not only discuss, but our discussions should also have solutions. Um, um, how we can address these situations, which was one of the positive things that happened with CBMs, was that within Kashmir we were able to meet. Both the sides of Kashmiris were able to meet, and so, for example, a very successful example was that a joint chamber of commerce was set up, a joint association of journalists was being set up, and lawyers, and that was being worked upon. But it came to a halt. Especially the trade was very critical, and although we faced severe issues that whenever LOC the aggression would heighten, the crossings would be closed, and the trade that was going back and forth would suffer severely. But post 5th August, it had like literally completely closed down. And so these small spaces of breathing pockets that we had have now been removed. So while there is this aggression and there is this conflict, we must find some way where any local, national or international association or organization could help the Kashmiris to meet. We we sh- we need to come up with some kind of instrument which does not block Kashmiris from meeting. And by meeting, it doesn't mean that this kind of meeting. For us to be actually able to physically meet, we're back to highs and waving across the LOC, which we've been doing for decades. So going from improving, and personally, I don't feel that the situation in Kashmir ever improved. It went from bad to worse and back to bad to worse, and then back to bad. That's the improvement, that the severity decreases. But there has never been a post 1947. Well, I would say even before that, since we were our the state of Jammu and Kashmir was completely violated by the colonials and then sold off to the Maharaja, because the colonials were too busy extracting their trade benefits from the subcontinent, and Kashmir was like this um, just far off place that needed to be buffered and could not be disowned, and so it was given to someone else that you take care of it, and the rental and transactional relationships that the colonials have always had. And so it's not just a story of decades but centuries that Kashmiris have been suffering. And one thing that has never changed, no matter who has ruled over Kashmiris, is the fact that Kashmiris have dissented. They have never accepted occupation. They have been killed regularly. And that for itself should speak volumes as to what is going on. Nowhere in this world is there any such territory where the world is not really concerned about the heavily militarized zone, about human rights abuses, about the way people are killed. Um, we don't have a Princess Diana who can highlight, like, she highlighted landmines and then they were um, um, blocked, or what's the right word, that you shouldn't be using them. Who is going to be that Princess Diana when it comes to pellet guns? These are not allowed. They should not be used on unarmed or even armed civilians, because even if Kashmiris are armed, they are not equally armed. The Indian forces are heavily armed, and the maximum that an a Kashmiri freedom fighter would have would be maybe a gun maximum, and that is seldom. It's only a stone. But the scale of aggression is so imbalanced. So somewhere this conversation needs to start, that scaling of aggression. What is India fighting for? Why is it maiming and abusing and killing Kashmiris who only have stones? The only other place that we see and this level of aggression against unarmed civilians is Palestine. The way Israel keeps attacking Palestinians, it has already usurped all the lands, and we see that happening to Kashmir. The Israeli model is being followed. Um, I hope we can come up with some kind of solution, but the way they're taking up and eating up Kashmiri land, we could be another Palestine. But until Kashmiris are alive, uh, this issue will remain alive until and unless either it is solved or Kashmiris are completely wiped out. There is no if and but between this. So we should be looking for those solutions. But thank you so much. I think I've spoke. I wanted to keep it as short as possible because we had experts who gave their worthy time, and I was just wanted to share what is happening at the local level and how or what we can do to improve our situation and help our people out. So over to Afzal and Tayyiba and Nasir. Once again, great work and thank you so much. Please do keep on having these conversations.
Thank you so much, Ms. Farzana Yaqub, for your explanation on the on-ground realities of what is happening, especially in Azad Jammu and Kashmir and the Indian occupied Kashmir. Um, you explained about the mental and physical toll on the human life that is happening there, and how it is not only just direct physical perpetration of crimes and violations of human rights, but also psychological warfare. Thank you for that. And I would just, I'm just looking at if we have any questions. Okay, no questions. Okay, so for some reason, I think okay, so I just don't want to take any more of your time. I must say today's webinar was highly informative, and I am sure that whoever is channel or was watching on the Facebook live stream must have created a lot of clarity on numerous issues of political and legal nature. It was quite fascinating watching professionals express their perspectives. Thank you again for such a lovely session. And on behalf of LFOVK, Allah Hafiz, goodbye, and see you later.
Thank you so much.
Thank you.
Thank you. Thank you.
Thank you.
Thank you very much, the team of Legal Forum for the Oppressed Voices of Kashmir, Afzal, Taiba, and thank you for having me. Thank you very much. Allah Hafiz.
Thank you so much. Thank you, Allah Hafiz.
Thank you.
Good afternoon,
Goodbye,
Dr. Hawks.
Dr. Patricia Hawks.
Thank you. Thank you. Thank you,
Thank
Taiba.
you so much for participating. It really means a lot to me. And everyone was looking forward to hear from you. And I mean, I hope we can interact again.
Sure. Yeah. Absolutely. Absolutely. Yes, no problem. Yeah, get in touch. Thank you so much. Thank you. Bye-bye. Bye.